Good afternoon, everybody. And I'm Ugo Pagallo from the University of Turin. And this year, actually last year, when thinking about how to present next year at CPDP, this is the fifth year in a row organizing panels here. I thought that Article 45 and adequacy should be a hot topic, but I couldn't expect how lively this panel is because of the adequacy decision presented last week by the European Commission. So, in a way, we are cutting edge. And moreover, we have a super adequate panel just to address these issues. We'll be dealing with Article 45, of course, but not only with Article 45. But straight to the point, let me introduce you the panelists. And first of all, Bojana, who will be our moderator today. She's the president of the Center for Information Policy Leadership and globally privacy and security policy expert, and with her center working between Washington, D.C. and London. Then we're going to have, I'm following the alphabet order, Jos Dumortier, a super expert, I must say, in our topic today. He's an honorary professor of ICT law at the University of Leuven and has been the founder and first director of the Interdisciplinary Research Center for ICT and Law, and currently a member of the Bar of Brussels and partner in Time Lex. Then Kristina. Irion is an assistant professor at the Institute for Information Law at the University of Amsterdam. Her research covers EU law and policy in electronic communications, online media and services, as well as, of course, privacy and data protection. And frequently, she provides expertise to the European Commission and the European Parliament, along with other institutions. Then we have Ralf Sauer, is the deputy head of DG Justice and Consumers Unit for International Data Flows and Protection in the European Commission. He has been one of the key negotiators of the EU-US Privacy Shield. And, well, again, our topic today is his bread and butter, so to speak. And last but not least, we have Professor Fumio Shimpo, a commissioner for international academic exchange at the Personal Information Protection Commission in Japan, and professor of faculty of policy management at Keio University. And his area of academic expertise is constitutional law, cyber law, robot law, and working as a former he was former vice chair of the OECD Working Party on Security and Privacy in the Digital Economy. So this is our panel. Then the floor is yours, Bojana, for our panel. Thank you very much.
Thank you very much, Ugo. Thank you for organizing this panel. I think it is because of this panel that some things have happened. Must be. Surely we have had adequacy decision because they knew we would have to talk about it. But I'm really delighted to open this panel today with this excellent group of our presenters. I'm going to ask each of them to give us some thoughts and ideas on this topic from their own experience and their own perspective. And as you have heard from Ugo, each of them has got a particular angle to share. And then we are really going to have a discussion, and we would like you also to ask all kinds of questions, because this is really important. It's all about data flows, which are fueling the economy, which are enabling competitiveness, innovation. It's all about making sure that we appropriately apply the rules of data transfers and adequacy. It is all about the new world out there that is, perhaps not adequate. Say Britain will be a third country, so it'll be very interesting to see how that and how that is going to pan out. And I know that many companies really do want to understand and demystify this whole process of adequacy decisions. So without further ado, I'm going to ask Professor Fumio Shimpo, who also you have heard is the commissioner at the Data Protection Authority, the Supervisory Authority Privacy PPC of Japan, to give us his perspective and lessons learned, right, from this case study, because I think that is a case study of mutual adequacy decision between Japan and EU that has just been declared and decision was made, as you have heard last week. So thank you so much, and thank you so much for being here, traveling all the way from Japan. It's fantastic.
Yeah, thank you, Bojana. Thank you for introducing me. I am Fumio Shimpo, Commissioner for International Academic Exchange of the Personal Information Protection Commission, PPC, Japan. So many people have interest in the result of mutual adequacy findings between Japan and the EU. So at this panel regarding what are the implications of the adequacy findings in relation to Japan for other countries. So I'd like to introduce the activities for mutual adequacy findings between Japan and the EU based on the experience of the dialogue toward adequacy findings carried out between Japan and the EU. Thank you. Yeah. And first of all, I'd like to briefly explain the background of the dialogue between Japan and the EU. In July 2016, the PPC decided the policy to establish a framework for mutual data transfer between Japan and the EU. The key word here is the term mutual. At the time, some company in Japan expressed their intent to adopt the adequacy finding from the EU. Since there are such similar provision and a certain comparability in the personal information protection system between Japan and the EU, the mutual adequacy finding will make economic activity smoother and will bring about an expansion in thinking about the data usage and data-driven business model. Based on this conception, the PPC decided the policy to have a dialogue with the EU with the aim of carrying out mutual activities for 2 years. As a development in the process of promoting industrial cooperation between Japan and the EU, the joint statement for EU-Japan regulatory cooperation was issued by the Keidan-ren. It is the Japan Federation of Economic Organization and Business Europe. Due to the situation, the mutual adequacy finding dialogue between Japan and the EU has accelerated. And this is the chart of the comparison of the regulation on cross-border data transfer in Japan and the EU, which is a prerequisite for the dialogue. The regulations are the disciplines for the provision of personal data to foreign countries. The left-hand side of the chart explains the regulation of cross-border data transfer in the EU, and the first item referred to is that of the data receiving country like Japan being recognized as a country which has ensured adequate level of protection of personal data. And the second item refers to the data receiving country in which the protection system of personal data has been established by the BCR or SEC. And the third item refers to the explicit consent of data subject. The cross-border data transfer of personal data may be made based on the meeting either of the condition in the three items. And also the right side of the chart explains the regulation of cross-border data transfers in Japan. And the first item refers to that of the data receiving country or region designated by the PCC, which has equivalent standards regarding the protection of personal data to those in Japan. The second item refers to a data receiving country or region which has established a system of personal data protection, which meets the standards specified by the PPC. And then the third item refers to the existing consent of data subject. the cross-border data transfer of personal data may be made based on the meeting either of the condition in the 3 items. From this chart, I think that you can understand that Japan and the EU have a comparatively similar institutional framework for regulating cross-border or border data transfer, with a view to mutually recognizing the other party as a country or region, which ensures an adequate level of protection of personal data. To realizing mutual findings, Japan and the EU with a similar institutional framework have had repeated dialogue since 2016. And in July 2018, the final agreement was reached between the PPC and the European Commission. In July 2017, Japan and the EU confirmed together the substantive measures to construct a framework for mutual and smooth personal data transfer. Both sides agreed the policy which Japan has designated for the EU based on the Article 24 of the Japanese Personal Information Protection Act, and the EU, on the other hand, has made an adequacy decision for Japan based on the GDPR. Continued intensive discussion on this matter are taking place after having met about 80 times and over 300 hours of discussion since 2016. Many discussions. Both authorities have reached a final agreement on the construction of the framework for data transfer between Japan and the EU. As you may know, based on the differing cultural and social backgrounds, it is natural to expect that each legal system will differ from country to country. Therefore, in regard also to their personal information protection system, there will be various differences between the APPI in Japan and the GDPR in the EU. Consequently, the construction of framework for mutual and smooth transfer of personal data should be premised on a mutual understanding of these respective legal systems. Thus, most of the repeated discussion over the past 2 years have been, Japan and EU have been about the need for establishing a mutual understanding. And finally, on 23rd January, just before the 1 week before the 2019, a framework for the mutual transfer of the data was constructed between Japan and the EU. I would very much appreciate that I could now introduce the joint statement between Japan and the EU here at this panel. This slide is very small capital, so could you check on the website of the PPC and also the European Union. During the adequacy findings negotiation, the 5 items listed on this slide became an issue. In order to bridge a gap between the legal system in Japan and the EU, both sides have a repeated discussion and have bridged the differences between the 2 systems by establishing the supplementary rules. Let me briefly explain these rules. As for the scope of the special care required information, it means the sensitive information. It was decided on the rules to treat the information on natural person, sex life, sex orientation, trade union membership in the same way as special care requiring personal information. This means the sensitive information. And then regarding the right of request for disclosure, the second part, this applies only to the need for personal data to be retained over 6 months based on the APPI. However, the supplementary rules provide that to respond to any request for personal data to be deleted within 6 months. Regarding the procedure for succession of a utilization purpose, the supplementary rule specify the utilization of personal data to be provided by a third party within the utilization purpose, and provided that this purpose was specified by the third party provider. And for the retransfer of personal data from Japan to foreign country, when transferring personal data to foreign country, based on the agreed ground, that the transferee business operator has established a system, it has been decided under the rules to ensure an equivalent level of protection to that in the APPI by concluding a contract. As for the anonymously processed information, this concept was newly established based on the amended Japanese Personal Information Protection Law. When treating this information as anonymously processed information, the rules provided to make it possible for anyone to re-identify the personal information by deleting the information by a processing method. And what are the key success factors in the mutual adequacy finding between Japan and the EU? I think that the first key factor is that both Japan and the EU had a mutual adequacy finding scheme under each legal framework. The second key factor is that regarding the protection of personal information, Japan has made an amendment of the APPI, Japanese Personal Information Protection Law, in 2015 with global standards. On the basis of such APPI and has reached almost there may be a kind of evidence that OECD privacy principles provide universal values. The third key factor is that both Japan and EU have high incentives to seek solid collaboration, including free data flow between Japan and the EU. The mutual adequacy finding will further facilitate commercial exchanges, thereby complementing and amplifying the benefits of economic partnership agreement. And as you know, the EPA, Economic Partnership Agreement with Japan and EU, will also become effective on the 1st February, the day before on the 1st February 2019. And thus, with the key factors in operation, we have been able to bridge the difference by formulating 5 rules under the supplemental rules. A data protection authority also may have executing authorities. And what is the legal basis for the formulating these supplemental rules? So in Article 6 of APPI, which stipulates that the government shall take necessary legislative actions, as stated on this slide, Article 6, there is a provision that the government shall take necessary step construction an internationally conformable system. So again, as shown this slide, in addition Article 6, the Japanese government decided to amend the basic policy on the protection of personal information initiative used for ensuring smooth international transfer of personal data. And finally, I'd like to introduce about what have learned regarding this mutual adequacy findings. So we have learned that the hard way that it has been very labor intensive to understand each legal system's approach concerning personal information due to the country and regions previously stated. So differing cultures and histories. And so it has not been easy to reach mutual adequacy findings. As our understanding of the legal system of other countries has led to a further understanding of our legal system, Japan would like to have an even greater understanding about the legal system of the other countries, including that of the EU. During the negotiation with the EU, the dialogue between the various enforcement authorities has been a very valuable experience. A relationship of trust has been built through the dialogue, which serves as a strong foundation for present and future enforcement cooperation. Thank you.
Thank you, Fumio Shimpo. I think 300 hours is about 40 working days of negotiations. That's probably without emails and travel between Brussels and Japan. But that's what it takes. And really, thank you so much for being here. I really think this is actually, it's a historic moment. I really think because it is under GDPR kind of, and it is, of course, mutual recognition and mutual adequacy decision. We will leave the questions at the end, but I'm going to ask Ralf Sauer with the Commission to tell us his side of the story and what have we learned from this adequacy discussions with Japan. But also, Ralf, would you also reflect a bit more on how is Commission going to be taking forward or what has Commission done in the past couple of years since you published that communication on your strategy for international data flows?
Yeah, thank you very much also for the first presentation, because I think that relieves me of the need to explain in more detail what we have done on this file, on the Japan adequacy. So from our perspective, I mean, if you look back to what we set out to do, and we did set out our strategy in the communication of January 2017, to be more strategic in the use of the adequacy tool, to focus on countries with which we have, in particular, large data flows, which makes a lot of sense, and not just, of course, from a trade perspective, although that's also very important, but also from a fundamental rights perspective, because where a lot of our data goes, we have an interest to ensure that it is protected when it gets there. So from that perspective, Japan was a natural choice. It's one of our most important trading partners. We have large exchanges of data. And of course, there's always a prerequisite for adequacy. I think one has to understand what adequacy is about in our rules. Because we are coming from a fundamental rights perspective, there is this need to ensure the continuity of protection. We have various tools for this, but we have one tool which actually, despite this requirement to ensure the continuity of protection, allows the free flow, and that's the most comprehensive and beneficial instrument that we have, and that is adequacy. But of course, with that comes a certain standard that we have to fulfill. We have to make sure that not that the third country law is identical. We're not expecting the GDPR to be implemented anywhere in the world. But we're looking for convergence. We're looking for a level of data protection which is broadly comparable to ours. And that's why we focused, that's the second reason why we focused on Japan, because Japan had just modernized its data protection law. It is a horizontal law. It has the same main principles, the same main rights that we are looking for, and it had created a powerful, independent supervisory authority that ensures enforcement. It also has other enforcement tools. I mean, not just injunctions by a supervisory authority. It also has the possibility for fines. It even has criminal sanctions. So, because it's important that there's not just law in the books, but also that actually means something on the ground. So the conditions were good to have that dialogue. And I think the fact that we have now managed it, I think, first of all, it shows that this is a real possibility under the GDPR. It shows that convergence pays off, because it really pays off. It in one go opens the market for all companies. It's not like a one by one. It's different from a contractual tool. It's different from a certification system. It in one go creates an area of a free trade area, if you wish. And there, of course, is also the link indeed to the European Partnership Agreement. That's another thing which we think can actually be can create a positive environment if at the same time you have trade negotiations or you already have a free trade agreement, where we always say that cannot cover data protection, certainly. You can then, in a separate track, achieve something similar if the conditions are ripe through, in particular here, mutual adequacy decisions, which then allow the exchange of personal data in both directions. So I think that's very important. The adequacy finding for Japan also shows that, and that leads me back in a way to the standard that we apply, that first of all, it's not identity of the rules, and secondly, even if there are certain differences, we I mean, with a bit of creativity and work, we can bridge these differences, and that's what we have done with our Japanese colleagues through these supplementary rules, which fill those relatively few gaps or differences that we found. I'm not denying that this takes a bit of time. Of course, here you also have to bear in mind that it was mutual adequacy, so it was not just us asking questions to our Japanese interlocutors, but also the Japanese side, rightly so, asking questions to us. We also have a new law that is maybe sometimes not easy to understand or read, and therefore there was also, of course, a need to explain our rules. And so that, and I fully agree, this made for a very rich dialogue, which indeed has created a very close cooperation relationship between us and the PPC and other parts of the Japanese government. And I also fully share the view that because PPC did more than just talk to us, they actually went to I think each of our data protection authorities, visited each of them. which I think is fantastic, because I very much believe in cross-border enforcement as the future, as something which is absolutely necessary if we want to have, I don't know, if you want that data protection is ensured cross borders and can follow in a way the flows of data, we need to also have the authorities closely cooperate and talk to each other. And I think that's also a very good outcome of the Sauer exercise, that this relationship has been established. They know each other. Not so long ago, the CNIL, French Data Protection Authority, visited Japan for meetings with PPC and a conference. So I think this kind of exchange is very important, and this adequacy dialogue can contribute to that. So I see a number of very positive elements in this. You had asked, so looking beyond Japan, what's next? I think I'm not revealing any secret that we are also in an adequacy dialogue with Korea, and that certainly has been a focus already in the past, but even more so now, and even more so because Korea is also considering further amending its general data protection law to create a fully not just a fully independent supervisory authority, but one with the real powers. So from the ministry moved to the PIPC, as it's called. So that's a great development, and building on that, we can hopefully then work this year towards a full adequacy finding for Korea. So that's in the making, and Korea has a very good data protection law with PIPA. And so I think there's a very good basis for that. It's also no mystery or secret that we will likely then also look at the UK. So for once, a very close neighbor that we will have to engage with. Of course, it all depends on what will happen. Certainly with the withdrawal agreement, because that has already been said even by the European Council. Once we have a withdrawal agreement in place, an orderly withdrawal with a transition period, we will use that transition period to talk about adequacy. The outcome is always you only know at the end, but I think the conditions again are very good, since the UK, of course, is by and large implementing our rules or incorporating our rules, which are currently in any event its rules under EU law. But once it has left, it will basically take GDPR and law enforcement directive into its national law. So that's already, of course, a very good start. It's not what we as I said, need. We don't need the same rules, but in this case, we would have them. So certainly for the commercial part and law enforcement part, I think the conditions are quite good. But so that's definitely also part of our work plan in a way for the rather immediate future, I guess. And then there's, of course, other focus areas, and you can see that in our communication of 2017. And again, this has to do with with considerations that link to the volume of data flows. So certainly there are other countries still in Asia that are interesting. There's India, there's Indonesia. Both of which are reforming or for the first time trying to put in place a data protection law, and which are very big markets, and in particular with India, I think, since we have a lot of processing in India of European data, again, we have an interest, not just the Indian side, but we also have an interest to engage on that. But of course, the conditions have to be ripe. Right now, we don't have a data protection law yet. And then there's Latin America, certainly also a continent which is very close to us in many ways, but also closely linked economically, and where important developments are taking place at national level, even at regional level, because of the Ibero-American standards that have been developed. and in certain countries, and you will know that in Brazil, data protection law has been adopted, and they're currently putting in place, hopefully, the independent authority that comes with it. In Chile, there is a data protection law in the making. Colombia already has a data protection law. So there are a number of countries which are, of course, of interest. Other countries we already have adequacy findings, such as Argentina and Uruguay. So, but there it remains to be seen. Of course, as I said, it all depends a bit on how these legislative developments go. But certainly these areas, these regions, and some of the countries that I mentioned are of interest for potential adequacy dialogue.
I'm dying to ask so many questions of these two negotiators in this process, but I think I'm going to leave this at the end, and I'm going to ask Professor Dumortier, who I know has been working on a number of these issues before. But Jos, is this adequacy finding way of converging the world, is this the way forward? Is this the easiest way if it's going to take 40 working days per country?
Well, actually, my plan for this panel was to say something about the effects of an adequacy decision, taking the Japanese example, on our clients in Japan. So I will give you simply an example of one of our clients. It's a company headquartered in Tokyo. They process sensitive data in the context of their core activities. And my objective is to try to understand what the effect of the recent adequacy decision is for this particular client. This doesn't mean that the effects on other companies can be completely different. So I warned you before that this is only one case, one example. So our Japanese company has subsidiaries in almost all member states, about 60 subsidiaries. So they are established almost everywhere in Europe. We have qualified all these subsidiaries as processors because the company works very centralized. All decisions, major decisions, also in the field of personal data processing, are taken in the headquarters in Tokyo. So in other words, our client is a controller headquartered in Tokyo, but it has always been a controller, and the main establishment, so there are many subsidiaries in Europe, the main establishment in the Union is in Brussels, because this is the location of the European Central Administration, from which all subsidiaries in Europe and the Middle East are managed on behalf of the Tokyo headquarters. There is an interesting side effect on this, side effect of the GDPR, and that is the fact that if you want to use the benefit of having a main establishment in Europe and a lead supervisory authority, you have necessarily, at least in my opinion, to work with one controller. So if we would have considered, for example, the subsidiary in Germany, where there is a quite large subsidiary of the Japanese company, as a controller as well, of course, this controller in Germany is only established in Germany. So the main establishment, you cannot work with the main establishment because the main establishment in the GDPR is linked to the notion of a controller established in different member states. And it's interesting because as a lawyer, we, in many of these international companies, there is a constant battle between local management asking more autonomy and the headquarters. So we are, since the GDPR, always on the side of the headquarters, insisting on the fact that they have to centralize as much as possible, because otherwise they risk that their subsidiaries in Europe will be qualified as controllers, joint controllers, even worse. And this is exactly what we want to avoid, because we want to work with one, as many companies, we want to work with at least as far as possible and as far as the GDPR allows it, with one supervisory authority. Of course, this is not always possible, because the subsidiaries in Europe, they have certain processing activities which they have to carry out because of the local legislation. And in many cases, the local legislation, implicitly or explicitly, determines who the controller is, and in many cases, the controller is the local subsidiary. But there we have to then to differentiate. And the picture is then that we differentiate between processing activities. For all the core processing activities, the headquarters remain the sole controller. So anyhow, to summarize, our Japanese client is what we call a Article 3, Paragraph 1 controller, established in Tokyo, but fully bound by the provisions of the GDPR. Whether there is an adequacy decision or not. And you feel already what my conclusion will be. So the personal data coming from the European Union, from the subsidiaries, or even data coming from external companies like insurance companies or banks and etc. All these data are processed in the context of the establishments in the European Union. Then most of these data go then to Japan. How this technically is done is perhaps also not unimportant. Most of these data are entered into local information systems, local databases in the subsidiaries, but these databases are continuously synchronized, replicated with central databases in the headquarters. So it's a continuous, let's say, feeding of data into the central databases. And as I said, all the means and purposes of personal data processing are determined by the central headquarters. Interesting is that, of course, we have also data transfers. So we also have to think of Article 45 of the GDPR, the topic of our panel today, because obviously the data go from the subsidiaries in the European Union to the Japanese headquarters. So we have a data transfer from the European Union to third countries. Before the adequacy decision, we needed, of course, another legal basis, a legal justification for these transfers. And in our opinion, this legal basis, the only possible legal basis, in our opinion, was Article 46, Paragraph 1. Our reasoning is we have appropriate safeguards because our Japanese headquarters, our Japanese controller established in the European Union, is 100% bound by the GDPR. And so the list in Article 46, appropriate safeguards can be provided by a legal instrument or by binding corporate rules or by standard clauses, etc. This list is, in our opinion, not exhaustive. Our reasoning is that in our case, the appropriate safeguards follow from the fact that the GDPR is applicable to all what we call EU data, data coming from the European Union, and processed in the headquarters in Tokyo. Also interesting is that, of course, our Tokyo headquarters, they exchange data, personal data, sensitive personal data even, also sensitive data coming from the European Union with other companies in Tokyo. So there are transfers from the Tokyo client, to other companies in Japan, which is not a transfer to a third country, but a transfer inside Japan or from Japan to another third country. And so how do we do this? Well, there we have recommended, and perhaps it's wrong, but we have recommended to use, if it is a processor, of course, first of all, data processor agreements, data processor agreements under Article 28, but also standard clauses. Why standard clauses? Our reasoning is, well, if you say that being established in Tokyo but fully bound by the GDPR, but transferring data from Europe to your headquarters in Tokyo, you can do that under Article 46, but you have to guarantee that the data subjects remain protected. It's one of the conditions of Article 46, paragraph 1. So it's the only way. So our reasoning there is that we use standard clauses with other Japanese companies if we do these transfers, because our initial promise in applying Article 46 was to guarantee that the European data subjects would remain protected. So that's so now I come to the effects. Now we have this adequacy decision. What is the effect on this particular company? Well, immediately, probably the effects are very little. So there is no immediate effect, as far as I can see. We say there is no primary effect. There are perhaps secondary effects. One of these secondary effects is, of course, that from now on, our Japanese headquarters, our Japanese company as such, as a whole, is operating in, as if I may say so, an adequate country which generates trust in commerce and business, etc. So it's certainly not something that we can minimize, but so that's perhaps one thing, one element, important element. Another element is that, as we have just heard, there is a chance that this whole process have brought the Japanese legislation closer to the European one, and one of course of the major difficulties that we face in cases not only in Japan but also with clients in Korea or in Israel or in other countries is that the GDPR in Article 3.1 says we apply, our provisions are applicable also to companies, for instance, in Japan, if they are established in the European Union, etc. But in many of these cases, and also for our client, the Japanese APPI, and so the Japanese data protection legislation is applicable as well, because they also claim to be applicable. And our client, in this particular case, has to apply both systems, so constantly balancing and try to be compliant with both legal systems, which is not easy. And the adequacy procedure can bring the legal systems a little bit closer together, but as Ralf just said, it is of course not, the consequence is of course not harmonization. You remain to be confronted with completely different conceptual frameworks, and the logic of the legal system is entirely different, certainly in Japan, perhaps less in other countries. So to conclude, there are a number of secondary effects, but the immediate practical effects on the activities of this particular case should not be overestimated. That's a little bit my conclusion, but again, I repeat, I certainly don't want to say that adequacy decisions are not important, because there are many other cases where the effects are much more visible and immediate. Okay, I will give back the floor to...
And I think you absolutely raise a critical point, which is that of interaction between Chapter 5, which are provisions on data flows, with that Article 3, famous Article 3 on territorial application of GDPR, and how do they work together now that extraterritorial application has been expanded so extensively vis-a-vis what was in the directive. It's $1 million question. I think we have to address this, okay? But we'll do that in the Q&A as well. And then final point, Kristina, you are the last, but absolutely not the least. I apologize that woman has been put last, but I think it makes sense to have you kind of give your views on this adequacy phenomena, because it is a global phenomena. I mean, other countries are copying it as well, as we have heard. Japan has got similar provisions, and there's so many other laws. So how does this work in the trade deal world?
Yeah, thank you, Bojana. And being the last has also some advantages. Because, of course, I can choose a little bit where I want to put my focus. I actually want to take another perspective and look a little bit how that interrelates with trade law and the EU trade law regime. And I want to start with saying that, of course, we have reason to celebrate that the mutual findings of adequacy between Japan and the EU are now in place and actually also effective. This is great. We have also much reason to be satisfied that the Commission has made some headway in delivering on its 2017 strategy, exchanging and protecting personal data in a globalized world. Finally, we have seen that the birth of a Commission unit on global data flow has breathed some new life into this whole procedure that was before, let's say, having rather a secondary existence. And I also think we see something brand new that may not be so obvious, because the Japan adequacy decision from the EU has also been a premiere in another policy area. And that is that we have one premiere. We have for the first time the catalogue of Article 45 applied, and we can see how that works, and perhaps have also now a model for other countries. But secondly, we also have to see that there's constantly talking about that this adequacy decision for Japan is creating the world's largest area of safe data flows. So this language, I think, has a lot to do with a totally different frontier we are facing, and that is that the adequacy decision with Japan is also implementing a political compromise, how personal data flows ought to be governed in EU external policy. And this political compromise says that basically this is done via adequacy regime and the GDPR mechanisms to facilitate transfers to third countries, and not, for example, giving it to the trade law department. And this has not been so clear earlier. In fact, we have seen that Japan wanted to have in the EU-Japan Economic Partnership Agreement also a commitment on digital trade and free data flows. This has been then put under a how is that called, a rendezvous clause, to wait with it and see how that progresses on the adequacy decision side of things. And we can now say that what we see is a hand-in-hand of, on the one hand, a trade agreement, that is liberalizing trade between Japan and the EU, and on the other hand, this comes bundled with an adequacy finding. Of course, we cannot say that this is going to happen now always, but I could imagine that it is also a way of going about it in the future where this is appropriate, let's say, considering a third country's legal framework. So I find that actually fascinating from the point of view how data flows will be governed. And with this, I think we should open the floor for the discussion.
Okay. Thank you, Kristina. Thank you very much. That gives us really excellent time to kick off our Q&A. So given that, so this is my first question, maybe, well, to all of you, but particularly Mr. Shimpo and, of course, Ralf as well. It is, so this was the first time that we have got this mutual adequacy, and Kristina, you've said premiere. I like that word. And this may become also, Ralf, I think, default for some of the other countries, certainly South Korea and others or Brazil, who also have this requirement that they have to designate a country adequate. But from Japanese point of view, I would be interested to know, what were you looking at when you were looking at the EU regime to decide on whether that regime is designated as appropriate from the API point of view, the Personal Protection Act in Japan. And then, Ralf, how are we going to, is this going to be the default for other countries, and what are you going to be looking? Remind us of what 45 says and what the European Court of Justice requires in terms of essential equivalence beyond just commercial data, but government access to data. So could we maybe discuss that first, please?
First, yeah, regarding the premium, Japan is the first country assessed by the EU having an adequate level of personal data protection after the adoption of the GDPR. And so the difference between the European data protection system and the Japanese personal information protection system is that the European approach is based on the human rights protection approach. This means that data protection is a protection of human rights. But on the other side, based on the Japanese personal information protection law, we have also case law protection, total privacy, and also the Japanese APPI also provides basic rights for the data subject rights. So therefore, we have a similar approach and similar regime. However, that is just a basic notion, that particularly from the point of the free flow of data. So we thought that the mutual adequacy finding will further facilitate commercial exchanges, thereby complementing and amplifying the benefits of the economic partnership, EPA. And actually, Japan is EU's second biggest trading partner in Asia. Unfortunately, second. First is China. So therefore, but Japan is the EU's second biggest trading partner, and together, the Japan and EU account for about a quarter of the world's GDP. So as you may know, and also there are many Japanese companies operating and conducting their business in the EU. And in most cases, they have to transfer mainly their employees' personal data. And also, not only such employee data, they have to collect and use the customer data. So this is, so therefore, Japanese company, and at the same time, the Japanese companies have to see a huge amount of cost for passing the legal services and also to compliant to the GDPR. So particularly the data transfer limitation, so they have to compliant to prepare the standard contract clauses or binding corporate rules. So there has been strong needs for obtaining adequacy decision to ensure stable personal data transfer from the EU to Japan. So this is a reason of the question.
Do you think you will be, Japan has got other ways in which data can be transferred outside of Japan, and you have showed that on your slide. Do you think you will be doing this exercise on designating a country as, having appropriate safeguards? Do you think you would do this with any other country in the world? Or you will be concentrating on other things like Asia cross-border privacy rules or other elements of Japanese law?
Yeah, at this moment in time, we do not have any plan for the next designation based on Article 24 of the APPI. So we had to concentrate the very tough negotiation between the EU. So therefore, at this moment in time, we do not have any such concrete plan. But in the future, the free flow of data, based on the notion of the free flow of data, we have to designate on another country in the future. But now, currently, we do not have any such plan or next designation.
Okay. So, Ralf.
No, that's interesting to hear. So, and I think that's good. So that Japan will also make use of its adequacy regime. It's not called that way, but designation. I'm sure they will. But on your question, so it's certainly not a requirement. No, it's not. It's nowhere written that we would only engage in adequacy talks if then the other side will also consider an adequacy finding for the EU. In any event, this is not a tit for tat. It's a quid pro quo. It's totally independent. Our assessment of the third country does not depend on what the third country might do under its international transfer regime. And there are countries that do not have an adequacy finding in their arsenal of instruments for international transfers. I think Korea, for example, you mentioned it, does not have that possibility. I don't know about Brazil at this point, but there's a number of countries that don't have it. It's true that other countries that now modernize their laws, because they are inspired by our rules, they put something similar into their laws, and then of course it would be interesting to see whether they, I mean, we would then maybe also ask them to consider us as adequate. We believe we have solid data protection rules, and therefore there should be good chances for that. But it's not a requirement. It certainly helps. It's certainly even more beneficial. It makes this whole exercise even more worthwhile because it indeed then creates a full sort of zone of free flow of data with protections. So that's a good thing, but it's not a requirement. I wanted to come back to one point. I mean, in terms of whether this is important or not. I know Jos has managed to find an example where. And that discussion is by no means finished, whether if you go from a processor to a controller, whether maybe there could be a reason if the controller is directly under the GDPR based on Article 3, whether that does constitute a transfer or not. That discussion is ongoing, or the reflection on that is ongoing. Certainly if it goes from a controller to a processor, the processor will not be under the GDPR. Because it will not target the EU market, certainly not individuals and customers in the EU market. So certainly there's a huge area of data flows where there is a need for a transfer tool, and where therefore an adequacy finding relieves you of the need to put in place, for example, contractual mechanisms or others. So, but yeah, we have one example where I think it might also be interesting in the future, and that's certainly the UK. The UK will have rules like ours, so I guess we would expect that, especially since we have a certain closer relationship, certainly currently, and then hopefully also in the future, with basically the same type of rules. There's no good reason why this would be a one-way street and not also going in the other direction.
Okay. So can I just probe a little bit more? And I'm not suggesting this, but it has been suggested that the EU would be very diligent in looking at the UK government access to data and surveillance requirements, because that is sort of part. I mean, that is also part of your adequacy assessment, isn't it? It's not just commercial data and just data protection law, but it's also the government access and surveillance.
Yes, I think we all know the Schrems judgment and why the safe harbor decision was annulled. Certainly that is part of the assessment, which does not mean we do the same type of assessment as we do for the commercial side. I think what we have to check is basically that there is no disproportionate access to data, and that also certain protections, of course, apply once data is collected. But we're not doing a full sort of adequacy assessment as we do on the commercial side. I don't think that's the requirement of the court. So yes, when we analyze any third country, and the UK would then be a third country, of course we have to carry out that assessment.
Right. And UK would have to do the same, right? Because now we have got that. That's going to be another dual, hopefully, adequacy decision both ways at some point, because UK under their GDPR.
I don't know. They would no longer be under. I don't know. They would no longer be under the Court of Justice. We will see how they interpret their adequacy standard. You assume that the Schrems judgment they would be bound by that in the future. Yes, I don't know. Well, that's for them to see. We don't determine their adequacy standard.
I have to ask this on Brexit, and maybe then you can ask a next question. And that is, if there isn't a deal, if there's no withdrawal agreement, there's no deal on 29th to 30th of March, how are European businesses going to transfer data to UK? Will they quickly have to put overnight model contracts after having spent a year renegotiating all their vendor agreements because of GDPR? Is that really realistic? Or Ralf, is there some mechanism by the board, by the commission, by whoever that can sort of create that moratorium transitional period? I think this is something that really everybody's asking themselves today. And I know I'm putting you on the spot, but please indulge me. See what would be possible. The boss says no, but hey, the boss is not here, so.
I don't think I need somebody else for that. But
Exactly.
first of all, we still hope that it's not going to be a no-deal Brexit. And if we have a withdrawal agreement, we will have a transition period, and that will allow us to hopefully then carry out an assessment that could lead to an adequacy finding. That was the whole purpose, to give us that time, and I hope that our British friends will realize that this is beneficial for everyone. If not, the United Kingdom will be a third country. I think that's the simple answer to that. So the same rules apply as for any other third country. It's of course true that the situation is a bit different because it will be a third country from one moment to the next. That's a bit different from other situations. It's also, of course, true that everybody knew that there was this risk that when we discuss a withdrawal agreement, that it needs two to tango, and the other one, unfortunately, is doing a lot of knots when doing this tango, and we don't know quite what they want. But it was always a possibility. No, I don't think anybody can say that all of a sudden, only since the House of Commons rejected the withdrawal agreement in its current form, that we never knew that there could be a hard Brexit. So. And plus, there are not just contractual tools, there are also other transfer instruments. Certainly, it's not for the European Commission to in terms of the powers even that we have to think about a moratorium. If what you mean is a kind of grace period of applying a law which is there. There's no basis for not applying it. If our data protection authorities have any ideas about going a bit more slow on enforcement, I don't know. That's not for me to say. But I don't think if they get a complaint, they can just ignore it. So that's the fact. If you deal with a third country, it's the consequence of that. Right.
Except that this third country kind of has the same level of privacy protection, and there's no risk and harm to any individuals for data transferred to the UK as of 30th of March. But there we are. Doesn't matter. That's the spirit of the law.
That's why it should be very easy, and because operators in the UK are very used to standard contractual clauses and BCRs from the past. They're using them now, not in the internal relationship with other operators in the EU, but of course externally we use the same rules. They will apply the same rules in the future. They recognize our, from what you know, they have already planned for the eventuality. They will rely on our standard contractual clauses. I cannot quite see why it would be so difficult to rely on these model clauses. I mean, the idea of the model clauses is that you don't need to negotiate them. They are there, they're approved. They are both sides, both operators on both sides are used to these rules. I mean, it's now clear that it's hopefully to everybody that it's a possibility. So certain planning ahead is probably the right thing to do.
What about questions from the audience, please? Anything you would like to ask or discuss or comment? Do we have any? Yes, please. And just raise your hand. And oh, there's a mic. And would you just introduce yourself as well?
So my name is Maurice Rukers. I work as a data protection officer. And my question is maybe to you. What you think about existing standard clauses when it will be changed to other regime? And can we apply it normally, or should we edit it according to regulation? Thank you.
We didn't hear you. You said, can we apply it normally or?
Or shall
Edit.
we edit or
To make them GDPRized?
yes, yes,
Yeah,
yes.
okay. Can we have another question quickly, and then we'll do maybe several together? There's one behind there. I'm sorry, you're going to have to run now. I'm so sorry. Just because I want us to maximize the time. So model contracts.
Hello, I'm Roger Salonga, PhD candidate, University of Turin. I have maybe 3 questions. The first is, given that on Article Section 46 of the GDPR provides for exceptions to the adequacy rule, what actually do states which are not compliant, which are not and have not been accorded the adequacy standard, what do they stand to lose? Exactly, because so far, European companies still trade with third countries under these exceptions, like standard contractual clauses, which and the rest, there are exceptions under Article 46. So, if a country, like maybe African countries, which have not yet been, none of them yet has had the adequacy standard, what do they really stand to? Is there really something concrete which, if they are not, they don't have this, they are not giving this standard or not by the Commission, would they really stand to lose something economically or maybe legally? And secondly, there's this. There's this. I noticed under the GDPR, one of the mechanisms for the adequacy is maybe human rights. The Commission takes into consideration human rights, rule of law, etc. So I was wondering, is it out of place to think that a country which maybe does not have the same human rights laws, even though it has nothing to do with exchange of data, maybe a country which does not allow for same-sex relationships, maybe, could that ever have an influence in determining whether a country should have an adequacy standard or not? Because human rights too are part of the criteria for determining adequacy standard. Thank you.
Thank you very much. Okay, let's take these 2 questions very quickly, and then the mic can travel. Yeah.
You think this was for me?
It looks like
Maybe it was for me.
you. Well, choose the first one, and then maybe we can have yours.
No, I was joking. So on the first question was on standard contractual clauses. Since you're DPO, I'm sure you have seen what the rules say. The standard contractual clauses, which the Commission approved under the old directive, data protection directive, continue to be valid. They can be used. There's a specific provision on that in Article 46 until amended, withdrawn. I don't know what the third word is. Struck by the court. I don't think that's what it says. So okay, so that's the legal answer in terms of what you can do currently. That doesn't mean, of course, that we are not indeed looking into whether there's a need to adapt them. Bear in mind that we're talking about appropriate safeguards. We're not talking about adequacy, what I want to say with that is that for appropriate safeguards, obviously you don't need the full GDPR. So the fact that the GDPR has changed from the data protection directive in some ways, and it's not a radical change. We need to reflect whether there is a need really to further adapt, to add something, because not everything that has gotten into the GDPR, which wasn't in the data protection directive, is necessarily an appropriate or necessary safeguard that you need to fulfill the requirements of Article 46. So, but we're doing this, and that's one thing. But we don't want to change the SECs several times, and we also want to see is there a need maybe to restructure the current SEC system. You know that we have 3 decisions, 2 are very similar. They maybe not cover every type of scenario because we, for example, don't have processor-to-processor SECs, and we have a dedicated multi-stakeholder expert group where we have asked these questions also to companies but also others, practitioners, academics, and so forth. Where do they see the need? What's the need of the market? The need that practitioners see for further developing this instrument, and we are collecting these answers, but we don't yet have a full picture on that. And then the last point on this is, of course, the ongoing litigation from the Irish High Court. so-called Trams 2 case, which of course also plays a role. And there's a bit of a question how to, in terms of timing, what is the best timing then to intervene on this? We don't know what the outcome of this court case will be. Of course, it focuses on one particular aspect, namely the use more than the instrument, but the use of that instrument in a situation where maybe there are questions about disproportionate government access or insufficient judicial redress in this respect. But there is, of course, a question whether that can be, although standard contextual clauses can never regulate the law of the third country, but perhaps there are ways to strengthen the possibility to intervene for data protection authorities, or there are more maybe additional responsibilities on either the data exporter or the data importer. So there are these questions which are related to that case. And so we will reflect on this together to then see in which way we maybe want to further develop the SECs. So that's, sorry, a bit of a long answer, but that's the answer to that question.
Do you want to answer this question on the Article 45, whether that includes also looking at the wider rule of law, human rights versus just data protection? Clearly does, but what's the impact?
Well, I'm not sure I would answer it in that general way. It's true that, of course, the rule of law situation indeed plays a role. Article 45 even says that. But of course, it has to be linked to the question of data flows. No? It has to be linked to the question, for example, of possibility to access the courts. If that's not guaranteed, and that's a more systemic, a broader question, that has to do with the rule of law. If that's not guaranteed, well, you're likely not going to be able to obtain individual redress and therefore have enforceable rights. And that is, of course, an important question for an adequacy finding. But the example that you mentioned, not every human rights problem that might exist in a country has a relationship to that. We might still wonder whether we, with certain countries, want to engage politically, but that's yet a broader question, and that goes beyond my paycheck and my remit. But that's then more a political question. But in legal terms, I'm just saying that not every human rights angle is related to the question of data flows.
Okay, I'm sorry, I do want to, Mr. Chair, can we ask the couple of questions at the end, and then I'm going to, you can close.
Okay. Just quickly, I know, of course, that there are very little adequacy decisions, so that there's no African country yet is, of course, not a big surprise. But I'm aware that Morocco and Tunisia, I believe, have joined now the Council of Europe Convention 108, and also this additional protocol, which is also, like, let's say, an anti-chambre, of preparing for getting full access to other, to the EU as well. And there's also a strong interest. For example, France has a lot of data processing in these countries, which used to be French or still speak French a lot. And for that reason, we are seeing some movement also here. Yeah, it's an interesting dynamic.
Thank you, Kristina. You're going to be the last, so very briefly.
Very quickly. My name is Abderazak. I'm a Moroccan lawyer, and now
perfect. Look, Kristina just called you.
Now data protection consultant at TNP, which is a consultant firm and CPDP sponsor. My question is for Mr. Ralf Sauer, but let me thank the Center of International Political Leadership for the recent publication about territory scope. It helped me a lot. I know the people thanks to Mrs. Nathalie Langay. My question is about the adequacy mechanism. Is it a take it or leave it deal with very specific requirements, or a negotiation mechanism which means that some countries could get better deal and have an adequation decision without being as GDPR compliant as others? Thank you.
Okay, very, very straight question.
Is
it a black box? And do we have transparency in the black box?
I mean, I think since we have already mentioned the Schrems case, of course, and since we know there's also a challenge against the current adequacy decision for the Privacy Shield, I think it's no secret that this is by now adequacy is a legal question. It's a heavily weighted legal question And of course there are standards. There's the overarching standard that the court developed in the Schrems case, and which has been then reflected in the GDPR, the essential equivalence test. And of course, there's guidance as to what that then means for when compared to, we had this for the directive, and we have it now for the GDPR. There's what's called the adequacy referential. So that's the guidance paper from the data protection authorities that have spelled out. So what does that mean for the principles that need to be there, for the obligations on operators, for the individual rights, for the enforcement by an independent supervisory authority. And that paper, you could say it already incorporates another paper that deals with the question of government access, which basically gives you the main principles in that area. So yes, that's the standard against which we assess adequacy. So no, there is no difference when we do that. Another question is, of course, no, you have to assess a legal system in its own right, and different questions arise, whatever third country you look at, and the solutions you might have to find are a bit different. Where that third country law might differ from our rules, it can vary a lot, and then you have to think about addressing that issue if there is one. So of course our decisions look a bit different, although the overall structure of the assessment is very identical. I mean, if you want to compare the decision on Japan with the decision on the Privacy Shield, you will see exactly the same structure. But of course, in the assessment, you will see differences, and in terms of what was, for example, added in terms of supplementary rules negotiated with our Japanese partners is something which you don't find in the Privacy Shield, whereas in the Privacy Shield you find things on the arbitration panel because of the problem of obtaining judicial redress, and you find something on the ombudsperson because of the particular issues that arose in terms of ensuring a way of a redress mechanism in the area of government access. So this addresses particular points that arose in the assessment of one versus the other country.
I just want to give a last word to Jos Dumortier. Jos, would you like to make any comments or concluding remarks on what we have discussed or you have heard? We have just scratched the scene on Chapter 5 and Article 3 relationship, but
it's very kind of you to give me the floor, but I think that it's obvious that most of the questions are for the European Commission and for our Japanese. If I would have sit on the other side, I would have asked also a question, yes. Perhaps, but it's a very short one. Also to Ralf, is there a trend or a chance that in the future there will be adequacy decisions in which, let's say, more focused on EU data, where foreign countries agree to give a privileged treatment to EU data, which is in fact, let's say, sufficient to obtain an adequacy decision for a foreign country?
I'm not sure I fully understand what you mean with privileged treatment. First of all, adequacy is focused on the domestic law on the existing domestic law of a third country, and that law will apply to data processing in that country. If it so happens that maybe there is a gap, a difference that we need to address, indeed, we don't necessarily have to. I mean, our requirement is not that that third country then addresses this issue, which is relevant for us for data coming from Europe, in a way that applies also to data collected in that country. So that's where then you can have maybe a difference in the treatment of certain data sets versus others. But that's, again, we're equally happy if the third country applies that across the board. But our interest, what we have to ensure is indeed that data coming from Europe throughout its life cycle is protected, and if there is need to add something, we can negotiate this and find creative solutions. Whether they are comprehensive or only for EU data, that's then another question.
Okay, with this, I think we have to close because we have got another panel. Thank you so much, everybody, for being with us. I hope that you found this useful. It was incredibly important moment that we had a chance to celebrate the first mutual recognition. I think it's important that Japan was here, presented as well. This is a topic that is on the intersection of law, politics, human rights, and I think pragmatism as well, because data is flowing left, right, and center, and we need to make sure that we ensure accountable and responsible data flows as well. So with that, please join me and with a big applause for our panel, and then the next panel.